This is the first lecture in Common Law 1. We start with the judicial power, even though that's the third article in the Constitution. We start with that because that's most germane to what we're going to be doing moving forward. A couple of things before we start. First, if I write something on the board, it's important, and that has to go into your notes. If I say this is important, or you should know this, that should go into your notes. I can't give you page numbers when I'm reading from the text, the common law casebook, because depending upon what edition you have, you may find that it's a different page that something appears on. But everything that I do discuss will be found in the section that is appropriate for that topic. So I will tell you what section it is. Also, the cases that you'll be looking at are not necessarily, although 95% of them are, cases that are, not precedent setting. In other words, there may be other cases that have occurred since, start the class, or just prior to it that we'll not be covering. If this was a law school class, we'd have to look at the most updated cases. Here, the cases are always, right, everywhere, law school here, really just for illustrative purposes. In other words, there are concepts, which you'll be tested on, and there are cases that demonstrate how the court, worked with that concept and the like. So, as a consequence, the cases themselves are important because they help you understand the concept. So you should know those. I'll tell you the names of the cases. They will be put in a new order on Blackboard, so you can see the cases for each section in the order in which we're going to go over them. Also, two other heads up here. The first is that you should read the case notes book. You should have gotten it, because even though I'm going to be going over it, you could follow along, or you'd be able to go and take a look at what we've discussed, or look at it beforehand, hopefully, so you understand what I'm talking about. So my lecture should be a second time through. The other thing is that don't binge watch these videos. All the videos on the legislative, authorities and powers is going to be last, because that's the most voluminous. The first lectures are going to be on the constraints on judicial authority and then executive authority. So the midterm is going to be on just those first two, which is the judicial and the executive authorities. And the reason for that is that the most voluminous section is with the legislative branch. So that will consume the last half or thereabouts of the semester. So that's the way we're going to proceed. I will read to you from some of the cases, but you should also keep in mind that the cases are briefed for you ahead of time here. You have them I'll be sending them to you, so you should look at those. They break down in a way the cases do when you look at them from the case notes, which you'll get, into the nature of the case, the name of the case, the nature of the case, a small fact summary, a rule of law, the facts, longer explanation of it, issues, holding and decision. So if you read all of that, you have a very good grasp on the case. And it will look, they all will look exactly like that. So you can see there. When you are looking at a case, keep in mind that we're looking for fact patterns. And what that means is the germane facts in the case and their relationship to the issue. Not all facts in a case are germane. In other words, the fact pattern, there's a whole set of facts, and those facts, not all of them, will be important to sort of the reasoning of the justices as they write, the decision. Okay? In every case, more or less, you're going to see that there are dissenting opinions. I'm not really going to focus too much on that, because I'm more interested in illustrating the way the court has decided the case and what their reasoning is. So that's going to get less play, but I will mention that they're there and they're important to take a look at. But we're not going to ask, or I'm not going to ask on the midterm or any test, the particulars of a dissenting opinion. The other thing about these cases is if you look at them and you understand them, when it comes time to take the midterm and the final, what will happen is it's open book, open note, right? So you'll be able to find the cases more quickly if you're confused about a particular question or the like. Now, the test is timed, so that kind of keeps everybody honest. In other words, if you don't know very much and you're just depending upon looking at things last minute, what you're going to find is you're going to run out of time. So if you get all the concepts and you understand, you've got your notes, you should be able to fly through the exam with plenty of time, probably left over. If not, you're going to be scurrying, looking for the particular cases and the concepts to try and figure out what they are. Googling things and so on and so forth. It takes a lot of time. And so that's what keeps people honest. Also, in terms of the exams, I look at every question because it's possible that I may have asked a question poorly and a lot of people get it wrong. So I would then adjust the test. I expect to see a nice bell curve. So if I get a bell curve on a question, I could say, okay, well, that question's fine. Typically, the questions aren't a problem and the answer choices are not a problem. The test is a hybrid sort of matching, multiple choice test, which we'll talk about before the exam. So you should be aware of the fact that what's important are concepts, terminology, cases. That's it. Okay. Keep in mind that the facts on these case notes that I just held up are the ones that are important. Okay. Last thing. Every single author of any law book has to make a decision about not only which cases they're going to use to illustrate the concept, but also what to extract in terms of what has been written in each one of those cases. The authors of these books sometimes are taking a 50, 100-page, a decision in a case, and they have to cull from that those things which they think are most germane to helping to understand the concept. So those aren't all going to be the same. And that's the major difference between one, common law case notes book, or case book, and another. It doesn't really matter how that deviates. You're going to get enough information to be able to be just fine. And so I wouldn't worry about that. All right, so we're going to start off with the Constitution itself. I'm leaving out the history. I'm leaving out what happened at the convention. I'm leaving out all of that because the historical concepts, the historical underpinnings are not, in my view, important to what we're doing. You can get that in American government class. You can get that in a history class on the document, the Constitution, and the like. There are a lot of documents and a lot of people that were well known at the time, or their writings were well known, that the folks at the convention used, the founders, to sort of piece together this document. So I don't want to spend a lot of time. There's not enough time in the semester to really go back and look at all of that. You can do that on your own or take another class on it. So what we're concerned here with is how this all works. Not how it came about, but how it works and why it works the way it does. Okay? So we start with Article 3, and I'm most concerned about Section 2 of Article 3. And it starts off by saying, the judicial power shall extend to all cases in law and equity, meaning any violation or any conflict about a particular law that's been written, or a conflict in equity, which means typically value, if there's a dispute over that. And it has to arise under the Constitution, the laws of the United States, and treaties made or which shall be made under their authority to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens, or subjects. That's a lot of verbiage. Think about what the purpose here is of the federal government. It's really to address, conflict. And if the conflict is within a state, we don't need the federal government to resolve that. But at the writing of the Constitution, the idea was to keep the states, sort of moving in the same direction, if you will. In other words, to keep the bond there. And so their job here is laid out in Section 2 is to address those conflicts that would happen across state lines or between the federal government and a state, or citizens of one state involved in some sort of dispute with another, or certainly any foreign entity, ambassadors, treaties, that sort of thing. Anything where one state can't honestly be the arbiter of the case. They can't arbitrate because they basically have a vested interest in it. You don't want someone that has a vested interest in a case deciding that case. So the easiest way to remember all of that is just to think in terms of, is there entity involved in the case outside the state? If there is, or it deals with the workings within the federal government, it's going to end up with the Supreme Court. Now, one thing to keep in mind, as you'll see, there is appellate jurisdiction and there is original jurisdiction. Under appellate jurisdiction, the court would decide what cases to hear that have been heard by the lower courts. Keep in mind that you only have a right to one appeal, to the appellate court, federal appellate court. The Supreme Court can pick and choose what cases they want to hear. They don't have to hear all the cases that petitioned for, so it's up to them. So no one gets, necessarily, right? No one gets the Supreme Court to hear their case because they just simply petition the court. All right. So next, in all cases affecting ambassadors, other public ministers, and councils, and those in which the state shall be party, the Supreme Court shall have original jurisdiction. Now, this is important. That means the case starts there. Now, since the Supreme Court is the final arbiter of the law, it also ends there. You can't appeal a Supreme Court decision to any other court. So under original jurisdiction, which is, this is the stuff they have to hear, and the case starts there, there's no appeal. Once the court makes a decision, it makes a decision. All right. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction both as to law and fact, right? With such exceptions and under such regulations as the Congress shall make. Congress cannot change original jurisdiction without amending this document. But it can change appellate jurisdiction. And so when cases get appealed to the Supreme Court could go ahead and accept those cases. But the Congress can say you don't get to hear these kinds of cases on appeal, and that changes it. Third, the trial of all crimes except in cases of impeachment shall be by jury, and such trial shall be held in the state where the said crime shall have been committed. But when not committed within any state, the trial shall be at such place and places as the Congress may by law have directed. So basically here, they accept impeachment. Some of the, I think, confusion around impeachment is, is it a trial? Is it part of a legal process? It's really a political process within a legal structure. What that means is, first and foremost, they need an approach, right, to how to deal with these issues. And still it comes down to evidence and all that. So it does have the feel of, and is, in a sense, a trial. But it's a legal process. But it is different in that, unlike trials and the like, at the end of it, there's no punishment attached to it other than, if found guilty, removal from office. If it's a crime, no one is going to prison for it. Once someone has been impeached, then they can bring you can bring charges against them for criminal activity and the like. Most people think of impeachment as it relates to the president. It's only happened 3 times in our history. Presidents were not removed in any of those cases. But impeachment is also of lower officials beyond the president. So the process is the same. Again, we don't hear about those because there's not real great public interest in some judge somewhere being removed because of some indiscretion. Treason against the United States shall consist only in levying war against them, meaning them being the states united, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on testimony of 2 witnesses to the same overt act or on confession in open court. Why does the confession have to be in open court? We want to make sure that someone has not been in any way influenced to make that confession or coerced, or that in fact they're innocent, but they've been charged with doing so. So treason is a really there's a high bar for that because treason is a very serious offense. All right, Congress shall have the power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. You have to have process. And it's about the individuals involved. Remember that. And so that's basically all we have on Article 3. You'll notice there's nothing about really about reviewing what Congress and the executive branch might do. So this idea that the judicial branch, right, can review laws made for their constitutionality or actions of, say, an executive, although they can look at those things today, that was not the case. The court, unlike the other branches, really had to carve out in really extensive way its role. Obviously, the court was put in place for a reason, but it's kind of left open. It's almost as if, the founders sort of like, let's get through this, let's just set it up, and we'll leave it up to the first Congress to kind of figure all this out. If you look at the rest of the articles, in the Constitution, it's just moving the furniture around. It's how the debts are going to be paid. It's about ratification, how that's going to happen. It's just sort of, the functional stuff. So it's Articles 1, 2, and 3 that are most important. Originally, Article 2, which is about the executive branch, was Article 1. But fearing that the states would look at that and say, well, they're giving sort of the spotlight to the executive, and we get nervous about that, right? Governors of states want to run their states. And at this point, states were dominant over the federal government. After the Civil War, that flips and has remained so ever since, where the federal government is dominant over the states. But by that time, the states pretty much were, a cohesive unit, if you will. All right, so we don't really care about, we're going to get to, a whole bunch of cases that kind of discuss a bit about judicial review, the right of the Supreme Court to review the acts of Congress and the actions of the President of the United States. Probably the seminal case there is Marbury versus Madison, and there's two sort of mindsets on this. Some professors feel that they should really cover Marbury versus Madison. Others feel it's unnecessary. I feel it's unnecessary. It does. There were other cases, but this is the case that is most associated with giving the court the right to review the acts of Congress and of the president. There is one interesting feature. There are several, but the interesting feature that I'd like to point out is that the states and the federal government were really pretty separate entities. And so how do you dictate to the states how they should deal with their citizens? Well, the clever way in which they get around that is in the 14th Amendment, which basically says that citizens of a state are also citizens of the United States. In common law 2, we go into greater depth on that particular point. But keep in mind what they've done is now they've made everyone have dual citizenship. So, think of parents. Both have a legal right to their children. So one parent could say to the other, you do what you want with our child, but it's also my child. You can't do what I don't want done. So here the federal government says, well, look, these are citizens of the federal government and of the state wherein they reside. So the states can make law and do what they will with those citizens, but they can't do things that violate the Constitution, especially the Bill of Rights, with the federal citizens. So it's sort of an interplay there. But Common Law 2 handles all that and goes to that in greater depth. For now, I just want you to understand that we have accepted that the court, the Supreme Court, has the right of judicial review. They get to look at those things. And if they didn't, we would have a very short course. There'd be really no need in going much further. All right, so the first thing we want to look at is, okay, what are the limits then on this federal judicial power to review and the like? And there are three primary limitations that are placed on it. The first is interpretive limits. So let me see if I can find a marker here. Okay. Interpretive limits. Now, the interpretive limits really, and I will apologize for my poor use of board space and the way in which I write on the board, but you're going to have to suffer through it. Sorry. So interpretive is really key, right? What that means is words. Now look, for lawyers, for judges, for people in law, for anyone writing policy, the legislative body, for the founders as well, their stock and trade are words. Think about it. What does policy really sort of lay out? Words. The founders, when they sat in the convention and they tried to figure things out, they looked at and were very careful with their wording. The stock and trade of those creating policy or adjudicating it words. In fact, people are often surprised when they read Supreme Court cases and other cases that they'll spend time looking up or trying to understand a particular word that seems pretty straightforward, but it's not. So what they'll do is they'll look at how that word was used, in the case of policy, how the Congress used it in committee and general floor in order to sort of write that particular statute. So what they meant is assessed based upon the context and the definition used and perceived at the time. So it's very important to go back and look at that, but also how is the word generally used at that point in time? Words change meaning, and you have to know where contextually in time that word was used and go back and look at its meaning, because words do change their meaning. So if you want to understand a particular piece of legislation or policy, it's important to be able to go back and figure out, okay, that's what that word means. And that word is critical to resolving the case. You'll see that one of those words is people. Now, we all know when we say people what we mean, but in the contextual base of, for example, the Second Amendment, which is what we're going to look at, it comes down to what people at that time was really referring to. So these interpretive limits are really important. The second is congressional limitations. There, as I said, there is the Congress of the United States, and they place limits, especially on the appellate side, right? So there's congressional limits that get placed on what the court can do or not do. And here it's basically, it's the ability of a Congress to restrict the federal court jurisdiction. Remember, appellate jurisdiction especially. Then there's justiciability limits, and justiciability, I will tell you that this and this, those are the two most complex. This becomes pretty straightforward. Congress says you can't do that, right? But these two require a lot of forethought. Here about the meaning of words and how it gets interpreted in the context, and here about what kind of cases the court will hear. So on the interpretive side, what we have is we have several things that we have to consider, right? First, that the court is justified in protecting the constitutional rights only if they are clearly stated in the text or intended by the framers. Those who adopt this theory, often called originalism, defend it, right, as a desirable way to limit unelected judges in a democratic society. What that means is, for originalism, and so you can think of this as right, originalism, you're going to see there's also non-originalism. For originalists, they're saying, look, the way you have to understand statutes and the like, you have to look at whether or not there's a constitutional right, at stake, and what that right means, and that means going back to the framers and the like. So what they're saying is you have to take what is originally in the document and its intent, and you have to say, does this present issue conform to that? Okay. Non-originalism says, and the reason for originalism is that we don't want unelected officials, the Supreme Court's not elected, to take what elected officials, the Congress and the President, have done and decide without the support of the people, because they're not elected, to make a determination about what is and what is not acceptable for review and the like. So there's that limitation. The non-originalists basically say things change. Judges deciding constitutional issues should confine themselves to enforcing norms that are stated clearly implicit in the written Constitution. Those are the originalists, right? The non-originalists disagree. They say that the view that courts should go beyond that set of references and enforce norms that cannot be discovered within the four corners of the document, that's what they should do. And that it's essential because things change. Now, in the interest of full disclosure, I'm a non-originalist. I believe that you have to allow that expansive nature. Too many things have happened and will continue to happen. Change is the one constant, and that means the court has to have some measure of fluidity. And the check on that is that the courts later on, as things change, can always overturn a decision. So, for example, in Con Law 2, Plessy versus Ferguson, we talk about the rights of different people, blacks and whites and that sort of thing. And in that case, they decide that separate but equal is fine. You both have water fountains. You both can use them, your water fountains. So it's separate, but it's equal. Fast forward a couple of decades, you get to Brown versus Board of Education, and there the court looks back and says, wait a minute, separate but equal inherently doesn't work. You can't be separate and be equal at the same time. But it took a couple of decades to get there. Things change. And the court looks at contextually those elements within that particular time frame. So I think it's important to understand that if we don't like what a court has done, there are a couple of options. One, the Congress can write or rewrite legislation that adjusts that court decision. The president, in executing the law, could execute it in a way that negates a particular provision. The president can do that. We don't expect the president to do that, right? They're the executive. They execute the laws. Congress writes them. The court reviews it. Once the court makes a decision, one would imagine that the legislative body says, okay, and adjusts future legislation based on that. And the president says, let me execute it. But that's not really the way it works. Remember that the court has no sanctioning power. The court can't lock anybody up, right? Can't punish anybody. So how does the court have power then if it has no enforcement power? Well, if the Congress and the president want future cases that the court decides in their favor to be respected, they need to respect those those decisions by the court that don't favor their particular point. So it's really an agreement that if we ignore the court, we're taking its power away, and therefore when it agrees with our particular position in the way they decide a case, and the president, let's say it's a legislative body they agree with, the president just ignores it, the court has no play. The court is no longer part of the governing process, and that's very dangerous. So the debate over how the Constitution should be interpreted and the extent to which the method of interpretation should limit the judiciary arises in all areas of constitutional law. We're still arguing over the same things. That's a very good sign. It's a sign of a healthy structure where basically you revisit things and you're still arguing over them. In a democracy, it's important to have arguments. Constrained, constructed, and reasonable, but nevertheless to have arguments. In some way, we've been arguing over this document for well over 200 years. The United States is the oldest form of government, not the oldest nation, on the planet. We're the furthest out in a democratic structure. And so that's valuable. And so how we approach these issues is important. One of the important cases here that I do want to go over is the District of Columbia versus Heller. And you'll get a case brief on this. So let's look at that case brief and how it works. First is the nature of the case. Keep in mind, always look at the year that the case comes to the court or that the court hears it. It is not the year that the case originally occurred or where the facts lie, but where the court hears it. Why is that important? Because of context. The same case heard not in 2008 as Heller is, but in 1908 lives in a different context. So to understand the court, you have to look at this. Now, this case is 12 years old. It's not uncommon for cases that still hold no new precedent, to go back 100, 150 years. But it's important to look interpretively at when that thing happened in context. So here is the review of federal appeals court judgment. The fact summary, the brief fact summary is the following. The District of Columbia appealed to the Supreme Court after a federal appeals court ruled that the districts, meaning District of Columbia, right, District of Columbia versus Heller, gun control laws were unconstitutional. Lower court says that those, the lower court's decision is, or the state, or the district is unconstitutional. So what's the rule of law? That's the next thing. What's the rule that is going to govern the court's decision here? That's what we want. The D.C. Code, 1, general bar against the registration of handguns, right? That's what we got to address. That's what we want to apply the rule of law to. 2, prohibition against carrying a pistol without a license. And 3, requiring that all lawful firearms to be kept unloaded, either disassembled or trigger locked, violate rights of individuals under the U.S. Constitution's Second Amendment, which permits individuals to keep handguns and other firearms for private use in their homes, even though they are not affiliated with any state-regulated militia. Keep in mind that Scalia writes this decision, and this is a dissent by Stevens and by Breyer, but the Second Amendment is still being argued about. What it means, whether we have the right or we don't have the right. This case lays out the way in which we might want to view that, right? This case lays out the particulars of the approach. Now, you've got to follow the reasoning here of the decision, okay? Now, the next step of the rule of law are facts. Now, this is not a fact summary. This is more of the facts that are necessary to look at the case. We talked about fact patterns. These are the relevant facts the court looks at. It doesn't mean there weren't other facts. It just means that the court, in their decision, doesn't give those other facts any weight. You have to be very careful with facts and fact patterns because the facts you choose must work to support your argument. You can't really write, the court can't, a convincing argument without supporting facts. Look, facts are everything, right? And if we're going to reason, we have to reason with those facts. You can't change the facts. You can't ignore the facts, right? You have to use the facts. Sometimes there are no facts. And then reasonableness steps in, right? Okay, well, it's reasonable. We can't discern whether this happened or that. But under either case, it would be reasonable to assume this. So there's some of that going on. All right, so the facts here. The District of Columbia passed a law that barred the registration of handguns, requiring licenses for all pistols and mandating that all legal firearms must be kept unloaded and disassembled or trigger locked. One of the points they're going to make is that if your gun is disassembled into parts, what good is it? Someone breaks into your home, you can't run to quickly assemble the thing, right? You'll see how they use that rationale. A group of private gun owners, represented in this case by Dick Heller, that's why you got District of Columbia versus Heller, sued the district. They claimed that the laws violated their right to bear arms under the Second Amendment of the U.S. Constitution. A federal trial court refused to grant the plaintiffs relief, holding that the Second Amendment applies only to regulated militias and not to private gun ownership. So there's the first level, a federal trial court, the court of origin, where the case must come into. So they said, no, D.C. is fine. But the U.S. Court of Appeals for the District of Columbia Circuit disagreed and held that Second Amendment does protect private gun owners. So you've got the federal trial court saying D.C. can do it. You get a federal appellate's court saying D.C. can't do it. It violates the Constitution. So you've got a major conflict. That's usually one of the things that has pretty large play in the court's decision to hear a case. You've got a discrepancy between a trial court and an appellate court, or a discrepancy between an appellate court and other cases that the Supreme Court has decided. Why? It's important for there to be consistency in the law. If there's no consistency, what's the law? How can you follow laws that are either inconsistently written, or applied. So the court's concerned with that. Let's clear this up. Let's make sure that everyone knows that this is how this must be looked at. So what the court's going after here is either the appellate court, right, and saying that they made a mistake by saying that DC doesn't have a right to do this, or the trial court saying the trial court had it wrong. If the court thinks someone has it wrong, the appellate court, that's the system coming up, the court would then say to that lower court, change your opinion, change your decision. They make them do it, right? So the question is, the district court appealed, arguing that the Second Amendment should not only apply to D.C. because it is a federal enclave rather than a state. D.C. is weird. It's not a state, and it's not a state because it was a practical matter. Whatever state you put the federal government in gives that state somehow some measure of greater importance. So the District of Columbia was carved out. It's not a state, and we don't go into this, but as a function of that, the way they're governed is rather strange. And that the D.C. legislation regulates but does not prohibit gun ownership. Heller disagreed on the merits and urged the court to review the case in order to clearly define the relationship between federal gun control laws and the Second Amendment. So the court comes forward and says, okay, we're going to look at this. All right, so what's the issue here? This is the next section in the case notes. What's the issue? And by the way, in your syllabus, I lay out all these different parts, nature of case, fact, and tell you why they're there and what they do. So the issue. One, general bar against the registration of handguns is an issue. Prohibition against carrying a pistol without a license is an issue. And requirement that all lawful firearms be kept unloaded and either disassembled or trigger locked violate rights of individuals on the U.S. Constitution's Second Amendment to keep handguns and other firearms for private use in their homes, and even though they are not affiliated with any state-regulated militia. Let me just say something about when you read in the case book, a decision. Again, they've taken excerpts. People are often confused because they read a decision and it sounds like the court is moving towards one position, upholding or not, right? And then all of a sudden it changes. I often tell students it's best probably to go look at the court's decision at the end to know where they're going to go. Because the way in which the justices really do this when they write their opinion is they make the argument on one side. Okay, they're saying this, and here's what's valid about that, and their interpretation of this makes sense. And you think, okay, they're moving down the road towards in one direction. Then all of a sudden it flips. It makes sense to do it that way. You want to lay out the arguments of one side, talk about its strengths and weaknesses, lay out the arguments of the other side, and then demonstrate why one side or the other wins the day. Okay, so that's very normal. Then comes the holding and decision, which is really important. This is what the justices say. So, the amendment to keep handguns and other firearms for private use in their homes, even though they are not affiliated with any, regulated militia. So, the court says yes. The D.C. Code's general bar against the registration of handguns, prohibition against carrying a pistol without a license, and requirements that the lawful firearms be kept unloaded and either disassembled or trigger locked violate rights of individuals under the U.S. Constitution's Second Amendment, which permits individuals to keep handguns and other firearms for private use in their homes, even though they are not affiliated with any state-regulated militia. Yes, it violates it. Second Amendment holds. But now the argument has to be made why it holds. And the issue here, first issue, is militia. Can you only have a gun if you are part of the militia? That has to be resolved. Once you resolve that, it's, well, who gets to have the guns and to what extent? Keep in mind, as I said, this is still an ongoing issue. It keeps cropping up. We keep hearing about it. Both sides seem to not disregard Heller, but argue, as you'll see, where those lines get drawn. What can you do to people that want guns? What kinds of guns are we talking about here? Any gun at all, or only specific types of guns? So the argument Scalia now has to make is it's people versus militia. Did they mean people when they said they have a right, Second Amendment right, or do they mean just people in the militia? That's key. Now keep in mind something. Words mean a lot in sort of context. And that means grammar comes into play as well. As an example of this, and it's just a small example, a comma, a semicolon, and a colon mean different things, right? So, for example, that's more relevant here. When you place a comma after something, there's independent and dependent clauses. Independent clause is a sentence. It's a complete thought. A dependent clause depends upon some of the information in the independent clause for it to make sense. It's not its own sentence. That makes sense. What I'm about to say relates back to the subject or the noun or whatever that I was talking about. If there's a semicolon, what you've got is you've got two sentences that are complete sentences. Again, there's other reasons for the use of the punctuation, but just to give you a sense of it. So you've got a semicolon. Typically that means, right, that both sentences are complete sentences, right? You could put a period there. But the second sentence is so closely related to the first in the writer's mind, they want you to know, even though they're complete sentences, these guys are attached. I often explain it as, well, that's why there's a period to comma. It's not quite a period we're using, it's not quite a comma. It means that these two sentences are closely related. The court will look at that and say there's a comma here. Why did they put a comma here? It seems small and insignificant, but the court has to really try and ascertain exactly what the meaning was. So now the argument has to be made by Scalia that people are different than militia. And so reading from the excerpt of the case, I'm not going to read it all, just so you get a sense of how these things are structured. You can't really say you've taken a class in constitutional law if you don't know the structure, if you're confused by that. So I want to make sure we're not confused by that. So they look at the Second Amendment. And I'm reading directly from what's been excerpted in this book, this case book, that I've asked you to get. Regardless of what edition it is, you'll be fine. The Second Amendment is naturally divided into two parts, its prefatory clause and its operative clause. The former does not limit the latter grammatically, there it is, but rather announces a purpose. Grammatically does not limit it, right? Purpose is not limited, right? Or limiting the operative clause. So what do we mean? Let's look at the operative clause. But first, logic demands that there be a link between the stated purpose and the command. Stated purpose, prefatory, and the command, operative. That there's got to be a relationship, otherwise it doesn't make any sense. It's in the Constitution. Second Amendment has a clause where the second part is not related to the first part. So this is logical. It's logical under normal, grammatical construction. Okay, so the operative clause first. So he's going to take pieces of the Second Amendment and begin to assemble it. Operative clause, right of the people. The first salient feature of the operative clause is that it codifies a right of the people. Right? The right of the people. The unamended Constitution of the Bill of Rights used the phrase right of people 2 other times in the First Amendment's assembled and petition clause and the Fourth Amendment's search and seizure clause. The Ninth Amendment uses very similar terminology. All 3 of these instances unambiguously refer to individual rights, not collective rights, or rights that may be exercised only through participation in some corporate body. They don't mean necessarily a business. They mean anything that's structured in this way. What is more, in all 6 other provisions of the Constitution that mention, quote, the people, close quote, the term unambiguously refers to all members of the political community, not an unspecified subset. Militia is a subset of the people. And they're saying, Scalia in his opinion is saying, look, everywhere else they use this, they're talking about the people, everyone, not just some subset, which is what the militia would be, right? Remember, words are the stock in trade, right, of the law. Okay. Reading the Second Amendment as protecting only the right to keep and bear arms in an organized militia, therefore, fits poorly with the operative clause's description of the holder of that right as the people. First argument is the people. It's not the militia. It's not a subset. It refers to everyone, right? Now, you can disagree. And to the dissent, they're going to say, well, wait a minute. No, but his argument is, hey, they've used this same term 6 other times, and it's always referred clearly. And the courts agreed it referred clearly to citizens, to people. So he's standing on he's got pretty solid ground here to stand on. If it means something different than that, then how do we interpret the other 6 times it's used? So consistency in the law. So he's trying to demonstrate there's a consistency here in the terminology. Very important, right? We start, therefore, with a strong presumption that the Second Amendment right is exercised individually and belongs to all Americans. Later on, he deals with, bear arms. Was unambiguously used to refer to carrying a weapon outside of an organized militia, to bear arms. Okay. Meaning of the operative clause, putting all these textual elements together, we find that they guarantee the individual right to possess and carry weapons in case of confrontation. The confrontation part is sort of assumed that's why you have guns. They're not talking about hunting here. That's not really the issue. The very text of the Second Amendment implicitly recognizes the preexistence of the right and declares only that it shall not be infringed. You can't stop it, right? There seems to us no doubt on the basis of both text and history that the Second Amendment conferred an individual right to keep and bear arms. Of course, the right was not unlimited, just as the First Amendment's right of free speech was not. So the right's not unlimited. That statement opens up opportunity to look at how it is limited or not. Now, let me just make a quick aside here so you understand about how these decisions are written. Scalia writes it. It doesn't mean it only has Scalia's point of view. There are dissents, but that's not what we're talking about here. Typically, someone's going to write this decision. They have to get other justices to agree. That means that what they're writing will go to the other justices. They don't do this in a collective. When they first get and they go around the table, making the decision about, hearing a case and so on and so forth, that's collaborative. But here, they're not face to face. It's being sent to each justice. The justices will send back that they have an issue with this or that, and that they can't support, the decision with that word or verbiage in there. And so there's a give and take. So although Scalia is associated with and wrote the decision, don't think that it's his alone. It has had extensive input from the other justices that have signed off on it and said, yes, we're in the majority, we agree. Okay, what about, when we look at, we're looking at the prefatory clause here. The prefatory clause reads, a well-regulated militia being necessary to security of a free state. Okay, so they look at this idea of a well-regulated militia. The United States versus Miller, now they go back, consistency in the law, in 1939. Right? We're looking at a case that happened in 2008, and they're going back to 1939. We explained that the militia comprised all males physically capable of acting in concert for the common defense. That definition comports with the founding era sources. It's consistent. Security of a free state. The phrase security of a free state meant security of a free polity, free people, not security of each of the several states. Polity is the people, right? So we've got what? He's bringing it together. It's about people, and the security is about people, not about the states. What about the relationship then between the prefatory clause and the operative clause? That history showed that the way tyrants had eliminated a militia consisting of all the able-bodied men was not banning the militia, but simply by taking away the people's arms, enabling the select militia or standing army to suppress political opponents. They're saying is that history supports the idea that they don't suppress the people, right, to run roughshod over them. They take away their ability to defend themselves. So one of the dangers here is by taking away the means by which to defend yourself, puts you in a democracy in a very weakened position. Okay, so he's building the case. But the threat that the new federal government would destroy the citizens' militia by taking away their arms was the reason that right, unlike some other English rights, was codified in a written constitution. The argument is often made today, it's a very weak argument. Why should people have guns? They can't protect themselves from the government. The government has bombs and planes and tanks. That's not the point. It's not the point that the government has greater armaments than individuals. It's that individuals have a right to defend themselves from other individuals and from the government. And without the access to weaponry of some sort, they stand no chance of doing that. Okay. Our interpretation is confirmed by analogous and arms-bearing rights in state constitutions that preceded and immediately followed adoption of the Second Amendment. Interesting, because what Scalia is saying is, this is what we mean. Go look at the states and go look at their particular constitutions as it relates to bearing arms. Not only before we ratified the Constitution, but even afterwards, and you'll see that they're consistent with our interpretation here. So the states are doing this. He's building a very strong argument here, right? A very strong argument. We now address how the Second Amendment was interpreted from immediately after its ratification through the end of the 19th century. Three important founding era legal scholars, now he's going to the scholarly interpretation, interpret the Second Amendment in published writings. All three understood to protect an individual right unconnected with militia service. The 19th century cases that interpret the Second Amendment universally support an individual right unconnected to militia service. It goes on later on. Like most rights, the right secured by the Second Amendment is not unlimited, saying, look, Congress has a right to change this, but not eradicate it, alter it in the margins and that sort of thing. As the quotation earlier in the opinion demonstrates, the inherent right of self-defense has been central to the Second Amendment. Self-defense against other people, against the government, even foreign intruders. A constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all. If justices, this is the unelected piece, right? If justices could just simply say, you can get rid of it, it's an amendment. The Constitution cannot be changed unless it is amended. You can't change it through regular, jurisprudence, the process. You can't. Now, that doesn't mean a decision can't impinge upon it. It can, but then there's recourse, like Congress, as I've said, writing new law or in some other way, another amendment or what have you, or altering the Constitution. To have, when the people adopt them, whether or not future legislatures, or yes, even future judges, think that scope too broad. And finally, in sum, we hold that the district's ban on handgun possession in the home violates Second Amendment, as does its prohibition against rendering any lawful firearm in the home operable. That's taking it apart. You can't take it apart. You can't say, look, you've got the gun, you have a right to it, but take it apart. A gun that is taken apart has no value. You got to put the thing together, and that takes time. Hard to defend yourself if you're busy putting your gun together to do so. Rendering any firearm in the home operable for the purpose of immediate self-defense. So the argument is an excellent one. It is structured. Now, when I say it's an excellent argument, it doesn't mean you have to agree with it. But you're going to have to attack the argument based on the facts it's chosen and the way in which it's perceived. And what Scalia has done here is he's placed all the particulars in the context of the idea of a constitution, the founders, state action, right, scholarship, right, and other parts of the Constitution that address these issues like people. Pretty strong argument. Can you attack it? Yes, that's what the dissenting opinions do, right? They go ahead and they attack it. So there's an example of the interpretive element here. It's just an example of it. You see how you have to interpret things in context, and he defines the word polity. He talks about the grammar. It seems pedestrian, but it is critical to an effective court decision, right? This leads us to the second, which is congressional. Now, under congressional limits, because we know in Article 3 of the Constitution provides the Supreme Court shall have appellate jurisdiction, and in Article 1, which deals with the legislative body, that gets revisited, right? And here, a good example is Ex parte McCardle. That's one that's often used to lay out, how the courts sort of approach and think about this idea of congressional limitations. There are several cases. also the United States versus Klein. And I'll look at both of those, and then we'll leave it at that in terms of what we talk about congressional limitations. Remember that Congress can always change the appellate jurisdiction and the like. So in Ex parte McArdle, again, 1868. We're going back to 1868 in order to look at, whether or not Congress has the ability to limit. So the nature of the case is appeal from denial of habeas corpus. Habeas corpus just basically means produce the body. That's how the courts say, hey, we want this. There's a writ that it's an order, a writ, but when we talk about habeas corpus, we want the people involved to come before the court. We don't want them to be refused or what have you. So the fact summary is that McArdle appealed from a denial of habeas corpus to the Supreme Court, but Congress passed an act forbidding the court jurisdiction. The case is coming, right? The court's been petitioned, but now it's on appeal, and the Congress says, you know what, you can't hear this case. So what's the rule of law? Although the Supreme Court derives its appellate jurisdiction from the Constitution also gives Congress the express power to make exceptions to that appellate jurisdiction. Right? And so after the Civil War, these are the facts. After the Civil War, Congress imposed military government on many former Confederate states under the authority of the Civil War Reconstruction Acts. McArdle, a Mississippi newspaper editor, was held in military custody on charges of publishing libelous and incendiary articles. McArdle brought a habeas corpus writ based on a congressional act in 1867. The act authorized federal courts to grant habeas corpus to persons, let them go before court, held in violation of constitutional rights, and also gave authority for appeals to the Supreme Court. The Circuit Court denied McArdle's habeas corpus writ, but the Supreme Court sustained jurisdiction for an appeal on the merits. However, after arguments were heard, so it's already gone there, Congress passed an act on March 12, 1868, that repealed that much of the 1867 Act, much of it, which allowed an appeal to the Supreme Court from the Circuit Court and the exercise of the Supreme Court by jurisdiction of any such appeals, past or present. So here's what's happening. McArdle makes the appeal. The court says, we're going to hear this thing. We have a right to hear this. Congress goes back to the table and says, no, you don't. We're changing your appellate right. You don't have the right to do this. So the question then becomes, does Congress have the power under the Constitution to make exceptions to the appellate jurisdiction of the Supreme Court? We're not going to address. The court decides the issue. You may come to the court with one issue, and the court says, yeah, that's not really the issue. We want to hear the case because of this. And they'll make a decision based on the issue they choose. Now, someone's going to win based on that issue. And the side that wins based on that issue doesn't really care whether or not the court heard their issue, just as they want. So there's an example of that. In the United States versus Klein, here we have a different set of facts, but the issue is, does a statute violate the separation of powers by commanding a court to draw certain conclusions from evidence before it and by directing the court to dismiss an appeal for lack of jurisdiction when it encounters such evidence? Can the court say no, right? And the answer is yes. This law does not regulate the court's appellate power as permitted by the Constitution. You can't write laws that just do that. It's a constitutional provision. Therefore, you're only able to render it or change it based upon that. I'm going to end this particular lecture. It's lecture 1A. There's lecture 1B coming, and I've put them together, but I'm cutting this one short of the typical hour and a half I would do because I want to make sure that it loads.